about that, folks. Having a hard time getting things set up here. In the meantime, good afternoon. Hoping everybody's having a good day, enjoying life, living life, loving life. Gonna get set up here. I got a couple things I gotta pull up here real quick. Because we're gonna talk about something rather important here today. Something that's on a lot of people's mind. It's one of the biggest problems with society today, along with the commercial aspect. And they do it because of the commercial aspect, and that is they destroy your family. They destroy it from the bottom up by taking the kids. So we're going to talk about that a little bit today. In the meantime, feel free to say hi. Hoping everybody's doing good today. Please feel free to share this message. And I got this one. And then I gotta open this. And we're just about ready here, folks. Good afternoon, Ira. I know you're going through some stuff here currently, so hopefully this will help you out, brother. And like I said, folks, share this. Share this. Share it now. This is going to be some valid information. Because first I'm going to do some reading, and I posted these links on my page yesterday, so you can go back and catch these links on my page and go through and read them yourself. But I wanted to go through and read some of this stuff and kind of give you a brief explanation of what's happening in some of these cases. And I've got a congressional record from the House of Representatives in regards to a specific case. And before we go any further, like I said, they tear up your family for commercial purposes from the ground up, the kids. And they do that because everything starts from the ground up. Anything you do has to have a foundation. It has to have a base. It has to have a core. It has to have something that is what they call fundamental. Think about that term, people. Fundamental. Are they literally trying to tell you that they are trying to fund a mental incapacitated person? Fundamental. Fundamental, the original root of it means a base, a core, a foundation. The foundation of their system is a commercial system, which they must have some assets from you. They are the investor. They are investing in you. And they are holding your children ransom to force you to do it. Because you believe in the Federal Reserve System. You believe that's the only way you can live. You don't have to. You don't have to educate your children through a public or private education system. You can educate them yourself based upon your own foundation. But that there is the inherent problem. Because most people don't have a solid foundation. They're still living in a fictional system dependent upon Federal Reserve notes. And so when they try to establish themselves as having a solid foundation, they're still going out to the stores and buying their products. They're still going to churches. They're 501c3 churches. They're still going to the city council meetings. They're still doing these things within the community that are proving their involvement and their substantive dependence upon somebody else's foundation. You'll never get your kids back if you don't have your own solid foundation. And again, I assert my truth is not your truth is not my truth. When it comes to these case laws and stuff that I'm reading here, you can't use these case laws for your case. You can't write up the same case law that somebody else had that seemingly is almost identical and expect it to work the same way. It ain't gonna happen. Why? Because you're using that case as the foundation. You can't do it. It's impossible. You have to prove you have your foundation, not someone else's. So, having said that, let's get on with it. Trying to make sure I get a full screenshot here, folks. Oops, that's too big. Well, we're going to do the best we can with what we got then. Okay, and this is just a compilation of decisions of the United States Supreme Court upholding parental rights as, quote, fundamental. Decisions of the United States Supreme Court upholding parental rights as foundational. We're talking about foundling hospitals, people. All these hospitals today are called foundling hospitals. And when you have a child born in a hospital, the paperwork is adopting the foundling, who is found as soon as they are abandoned because mom and dad don't know how to create their own foundational documents proclaiming that person is theirs and not the state's. If you're going to create your foundation, then you have to create your own foundation. You can't be dependent on somebody else creating one for you. The United States Supreme Court, or the Supreme Court of the United States, has traditionally and continuously upheld the principle that parents have the fundamental right to direct, dual, rection, rules, dual rules. If you're going to have one foundation, you can only follow one set of rules. If you're going to have one master, you can only follow one master. Tear apart every word they use in their documents, their court proceedings, their case laws, everything, and use it to your situation. The foundational right to supervise the education and upbringing of one's children. A review of cases taking up the issue shows that the Supreme Court, and before we go any further, issue is a commercial term. That the last issue of the newspaper, it cost you. If you want to get a current issue of the or if you currently want to get an issue of an old newspaper, it's going to cost you. If you want a issue of a paper in the future that will be current at the time, it's going to cost you. It's an issue. Every document that they issue you at the hospital, they're issuing you a document. It's a commercial transaction. It's an exchange. A review of cases taking up issue taking up the issue shows that the Supreme Court has unwaveringly given parental rights the highest respect and protection possible. We all know this is not true. We all know this is not true. We know this is not true because the state courts and the state Supreme Courts are not being held to the Supreme Court of the United States standard. And therefore, their oversight into the state district courts. They're all district courts, and they're all under United States courts. Therefore, the Supreme Court of the United States has not unwaveringly given parental rights the highest respect and protection possible. Period. I don't care what they say. However, what follows are some examples of the court's past protection of parental rights. In Meyer v. Nebraska, the court invalidated a state law which prohibited foreign language instruction for school children because the law did not promote education, but rather arbitrarily and unreasonably interfered. The court invalidated a state law which prohibited foreign language instruction for school children because that law did not promote education, but rather arbitrarily because they thought they had a contract with the local school district, which they do, but because it's a contract, they have to go into arbitration in order to prohibit foreign language instruction that the local school district provided as reasonable. That's what this court decision says. The court invalidated a state law which prohibited foreign language instruction for school children because the law itself did not promote education, but rather, through contract issues, determinations, terms and conditions, arbitrarily and unreasonably did not come to a meeting of the minds with the school district and arbitrate that law. They just wrote it up and said it prohibited foreign language instruction for school children. That's an interference with the local school district. You cannot make a contract and then later legislate state law prohibiting something in that contract. You cannot do it. Vice versa. Each and every mom and dad has an inherent duty to be the ones that look out for the best interest of their children, and no state law, no federal law, no district school rules, regulations, nothing can inhibit that unless mom and dad let it. That is your ultimate responsibility in all of life, is your children. If it were not for having the ability to have children and pass on your legacy, you would have no reason in life to begin with. And then to let somebody else arbitrarily and unreasonably present to yourself without questioning it because of your fear, let them take your children. Never. Never in my day would I let that happen. The natural duty of the parent to give his children education suitable to their station in life. State. What state are you in? What state? What is the foundation that gives you standing and status. What is the core of your beliefs? What do you base them on? Do you base them on your life and the inherent responsibility that is superior and supersedes all else, and that is your children? Or do you believe somebody else and their foundation of some supposed safety concerns that they legislated into some form of writing? The court chastened the legislator for attempting materially to interfere with the power of parents to control the education of their own. Materially to interfere with the power of parents to control the education of their own. The decision clearly affirmed that the Constitution protects the preferences of the parent in education over those of the state. In the same decision, the Supreme Court also recognized that the right of the parents to delegate their authority to a teacher in order to instruct their children was protected within the liberty of the 14th Amendment. If you have a contract, if you go to the school and you register your children, just like the state cannot go in and arbitrarily and unreasonably legislate an invalid law prohibiting foreign language, you either cannot go to the school after you signed your children up and then propose to delegate authority further and beyond that. You, again, just like the state, have signed a contract and must go to the school and arbitrate with them reasonably. If your children have a field trip planned and they send you a notice saying that they are taking your children on a field trip, you have the right at that point either to sign that and say it's okay, agreeing to their stipulations whether you know them or not, or you have the right to go to the school and arbitrate with whoever's taking them on this field trip and find out the reasonable details of that trip so you can then come to a meeting of minds and determine whether you should give them permission to take your child on a field trip or not. This is process, people. This is the process that's due. It takes your own thinking before you sign anything. Each and every new document is a new or addition to a contract already in place. If you have a contract and you want to have an effect on it, and your child brings home this slip of paper saying that they're going on a field trip, and it doesn't give very many details except asking for your permission to say yes, I strongly suggest you go find some more information so you can better clarify whether you should actually give them permission. If they're taking your children on a field trip to go to a museum, but they don't explain to you that the museum is that of an LGBT, which you are totally against, and you say yes, you're the one that's conflicting with your own morals. And if you are conflicting with your own morals while sending your children to a public education system and then signing off on documents that then turn around and send your children to on a field trip to an LGBT museum, your child is going to see that conflict in yourself. Your children are not stupid. However, if they see that conflict and they can no longer honor or respect you, they're going to go to someone else. This is the importance of building a foundation, a solid foundation yourself first. Men, women, and then once you have become Average, true, age, average, true age, not age of majority, not a minority, not an adult, not a child, not a person, but average. When you become average and can conduct your own affairs as an adult, then you go seek a partner. Once you get a partner and you find out that it is workable, then you have children. If you have a partner and you have doubts whether it's workable, then you shouldn't even be having sexual intercourse. You need to make sure that the foundation that the both of you have built can be connected and intertwined reasonably so it remains a solid foundation and not one fluctuating between the differences between the two of you, so that as your children grow up, they see these differences and you're constantly arguing about them. It doesn't work. And they use this stuff against you. Furthermore, the court emphasized the 14th Amendment guarantees the right of the individual. That's a person. It's not guaranteed. The 14th Amendment cannot guarantee you shit. The 14th Amendment does not apply to you. It applies to persons. If you don't recognize this, quit signing stuff and learn it before you sign another document. To establish a home and bring up children to worship God according to his own conscience. Con with science. Imagine that. God has something to do with conscience. In 1925, the Supreme Court decided with Pierce v. Society of Sisters, thereby supporting Myers' recognition of the parents' right to direct the religious upbringing of their children and to control the process of their education. Again, control the process means you do not have to use a public education system, and you do not have to use a private education system. You can create your own system by process. Pure and simple. It has nothing to do with curriculum. That's their process. Got it? It has nothing to do with registration. That's their process. Got it? It has nothing to do with grades and passing this test or passing this exam. That is their process. Got it? In Pierce versus Society of Sisters, the Supreme Court struck down an Oregon compulsory education law. This is the Supreme Court. And it struck down an Oregon compulsory education law. Equality among the states. That Oregon law for compulsory education that got struck down by the Supreme Court got struck down in all 50 states, which in effect required attendance of all children. That's a person between ages 8 and 16 at public schools. And I'll tell you why they did that. It wasn't, as we saw up here, that the parents have the right to direct the religious upbringing of their children and to control the process of their education. It had to do with the simple fact that they cannot require compulsory education at public schools when there is obviously an option of private education systems. So despite the looks of the intent of the wording here, these governments to this day, these state institutions to this day, these district school districts, these local school districts to this day enforce compulsory education in one way or another because they are still only looking at it as though it's a public or private school system, and not the fact that each parent has the right to direct the religious upbringing and control of the process of their education. Comprehend this, people. You cannot use this case in this context to say, well, they already disallowed compulsory education because they can't require attendance of all children between ages 8 and 16 at public schools. That isn't going to clarify your case that you have the right to direct the religious upbringing of your children, of your legacy. Do not use children. It is my inherent duty as this little one's mom to supervise the faith building of my little one and to guide the process of their experience, knowledge, and wisdom. Do not use their words. Reconstruct this in like wording with words of equity that are true and cannot be rebutted. That's how you use their case law. You don't refer to the Supreme Court case decided. You use that as a side note to reference the language that you are using in like wording. Compulsory education, public schools. The court declared under the doctrine of Meyer versus Nebraska, we think it entirely plain that the Act of 1922 unreasonably interferes with the liberty of parents and guardians to direct the upbringing and education of children. And it says emphasis applied. Now their emphasis applied, I don't care what it is, because I will reaffirm this. And I'm going to break here because I want you people to comprehend. And look in my face. Look at me as I tell you this. I don't give a rat's ass about any of your rights. If you want to profess to be looking out for the best interest of your children, you better be stating something that none of these cases look out for, none of these cases mention. And that is your little one's rights. That is your inherent duty. While you walk around crying and whining about how I don't have rights. You want to step up to your rights, then you better step up to your ultimate superior right and duty that supersedes everything else in your life, including yourself, once you become that supposed adult, you now have a duty to bring forth more life. You want to beat these cocksuckers in these court cases taking your little ones? Stand up! Not for yourself. For them. How many of you are willing to stand along the roadside with 10 of these people standing there with weapons armed, and it ain't even your children? How many of you are willing to stand in the midst of 8 of them, questioning you, thousands of miles away from those children, while those children are on the run and they call them fugitives? And basically stand there and tell them, fuck you. You want to stand up for these children? You better stand up for them and know that that's your responsibility. Excuse my passion there. Excuse my language. We're not going to calm down and go back to this. Because now we're going to look at this congressional record. This is congressional record. You can look this up. Again, like I said, I posted this on my page yesterday. And this is expressing sense of House that Ninth Circuit Court of Appeals infringed on parental rights. Congressional Record, Volume 151, number 152. And you can look this up. It says text available as text PDF. This is not the PDF. This is their congressional record here. The PDF will be different, as we will see here. It will start. This actually is not the actual PDF I was looking at yesterday. Let me find that. Oh, I was looking at this one here. It says entire issue PDF up here. And it says Part 1. And as we look at this, you see the seal of the United States of America, congressional record. It's got the header. This is the title. That's the title. Proceedings and Debates of the 109th Congress, First Session. So this is going to have all kinds of stuff. This is going to be the hundreds of pages of the entire congressional record. This here, however, is going to be discussing Volume 151, number 152, where we're talking expressing sense of House that the Ninth Circuit Court of Appeals infringed on parental rights. This is the only issue within this congressional record that this part is actually talking about. It's not talking about the whole congressional record we saw on the PDF, Part 1, Part 2. But if you want to see that whole congressional record, that's how you read this page. You got home, congressional record, November. And congressional record here, when you click on that, it'll give you the scores of the other previous congressional records. So this is the part we're concerned about. And it says, Mr. Sensenbrenner, Madam Speaker, I move to suspend the rules and agree to House Resolution 547. That'll tell you where this is at, expressing the sense of the House of Representatives that the United States Court of Appeals for the Ninth Circuit deplorably infringed on parental rights in Fields versus Palmdale School District. Fields versus Palmdale School District. Again, along with these 2 postings here, I posted this with this and Fields versus Palmdale School District in a post yesterday. You can look all this stuff and do your further research. This Fields versus Palmdale School District speaks specifically about said case where I was speaking of earlier. They were doing a thing like a class field trip. They were doing they were having somebody come in and they were going to give 1st, 3rd, and 5th graders a test, a psychological test that they explained to them they would be answering some questions possibly about violence in their younger days that might make them uncomfortable. Well, the parents went ahead and signed this thing and had their kids do the test, and then only when the kids came home from school did the parents find out that there were sexually explicit questions asked. And then, and only then, did the parents come up in an uproar and raise this issue we see here. Wrong way to do it, people. Granted, the Supreme Court agrees, but it's the wrong way to do it. When you get those documents from the school asking you to give them permission, ask questions. I want to see this test. I want to see the questions that are going to be asked. If you do not have a copy of this test available for my review and the rest of the parents' review, so we can come together and have a meeting of minds to reasonably determine whether we want our little ones to be partaking in that test, then no, I'm not going to give you permission. If I find out that you had my little one to take this test with the others, then I will remove my little one from that school, and those doors will belong to me. Stand up, people. These are your children. This is your responsibility. Period. Whereas the Palmdale School District sent parents of elementary school students at Mesquite Elementary School in Palmdale, California, a letter requesting consent. They were requesting. They know they can't do it without your consent. This is the first thing that should give you a clue that you need to come to a meeting of minds. If what they are saying on the paper does not make sense to you or not very clear, then you should get with them for a clarification, to give a psychological assessment. What are they assessing? While they are professing to hold no child back, they're checking your children in a psychological manner to see if they should hold them back. Questionnaire to their first, third, and fifth grade students. Whereas without the informed consent of their parents, the young students were instead administered a questionnaire that contains sexually explicit and developmentally inappropriate questions. This is the part where the parents say, well, we didn't know anything about that. Whereas 7 parents subsequently filed a complaint against the Palmdale School District in a federal district court. Whereas on November 2nd, 2005, a 3-judge panel of the Ninth Circuit Court of Appeals affirmed the decision of the United States District Court for the Central District of California in the case Fields versus Palmdale School District, and held that the parents have no constitutional right. They don't. To prevent a public school official providing its students with whatever information it wishes to provide, sexual or otherwise, when and as the school determines that it is appropriate to do so. You parents signing these school registrations saying you are willing to follow the school curriculum have already made that agreement. In this situation, they have got somebody coming out from outside the school district to do a psychological assessment that is not part of the curriculum. That's why they need the parents' consent, further permission, because it is not in the original registration. Whereas the Ninth Circuit stated, once parents make the choice as to which school their children will attend, once they filed that registration, their fundamental right to control the education of their children is at least substantially diminished. When you sign your children up for school, they are admitting that once you register your child for their public or private administration, you are diminishing the education. You are not looking out for the best interest of your children, and they are stating so right here, in, on, and for the record. Once parents make the choice as to which school their children will attend, you've made that will. You've created a will and testament, in part, as a series of will and testaments. You are proving your will every time you sign a document. Attend their fundamental right to control the education of their children is at least substantially diminished because you allow the school system to direct dual rules. Dual rect rules. Dual rules. You are doing this yourself, people. Whereas the Ninth Circuit stated, whereas in Meyer v. Nebraska, 262 U.S. 390 401, the 1923 case they're talking about still stands on the record. The Supreme Court recognized that the liberty guaranteed by the 14th Amendment to the Constitution encompasses the power of parents. You are not a parent. You are not you're not partaking of the entities. You are the whole that which the entities are protected by. To control the education of their, look at that, it's even in brackets, children, another person. The power of parents to control the education of their children. If you sign, you are signing as the parent. And as the parent, you have substantially diminished your own rights inherently. Period. Simply because you don't know what you're doing when you sign those damn papers. Whereas the Supreme Court in Pierce v. Society of Sisters, 268 U.S. 510, 534, and 535, 1925 case, highlighted the Meyer Doctrine, the previous case, that parents and guardians have the liberty to direct the upbringing and education of children under control. Parents and guardians is legalese, people. You guys paying attention here? Social Security Act of 1935, aka Social Security Act 1954, an act to provide for the general welfare by establishing a system of federal old age benefits and by enabling the several states, capital S, meaning corporate states, to make more adequate provision, same as federal capitalized, it is the corporate federal, corporate states, to make more adequate provision, provision, pro as in forward, as in project, forward vision, as in television. You could replace provision with television, and it would mean the exact same thing. Several states to make more adequate television for aged persons, blind persons, dependent and crippled children, maternal and child welfare, public health, and the administration of their unemployment compensation laws, to establish a Social Security board to raise revenue and for other purposes, and for other purposes, and for other purposes, and for other purposes. How come nobody's asking what these other purposes are? Huh? How come nobody's asking what these other purposes are? How come no one is asking what these other purposes are? Purpose. 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 D. That, by the way, folks, was Social Security Act 1935 preamble. Look that up. This here, folks, is Social Security Part A, General Provisions. All you got to do is type in Social Security Title 11, Section 1101, and go down to D. The last one, you're going to find at the bottom of the page. Go all the way to the bottom where it don't go down no more. And it's D. Nothing. No thing in this act, capital A, shall be construed limiting it to the Social Security Act, shall be construed as authorizing any federal official, corporate agent, corporate, capital F, corporate, official, agent, or representative, anybody who represents that they are trying to enforce anything having to do with anything related to any purpose, having to do with any issuance of the Social Security number or information related in any way to the Social Security number in carrying out any of the provisions, any of the televisions of this act to take charge. Every time you go to court, they're charging you. What are they charging you with? They're charging you with some other purpose. They're charging you with some other purpose. Of any child over the objection of either of the parents of such child or of the person standing in loco parentis, the local parental, local parent, local parent. The local school district is the parent. The local county registrar is a parent. The local state is a parent. The federal government is a parent. The mother that signed the documents at the hospital is a parent. The father listed on the paternity paperwork is a parent. All parents are persons. As a mom and dad, no person can take charge of any child over that objection, regardless of either of the parents of such child or the person standing in loco parentis. It's telling you right there, the state, according to the Social Security errors that you've already made, is claiming that they have standing in loco parentis, and this, people, is what you must rebut. I am not that child's parent. I am not that child's father. I am not that child's mom or mother. That child is my legacy. And I am legacy to our Father who art in heaven, and hallowed be thy name. For thine is the kingdom that come in our mother earth, as it is in heaven. How dare you or anyone else profess that you can take charge of my legacy over my objection by calling my legacy a child? I'll discern whether my legacy is average. I'll determine whether my legacy is a delinquent. I'll determine whether my legacy is capable of discerning his own views and opinions. I'll determine when that happens. And if I determine it happens when he has reached a year in the sum of 16 and so many days, then so be it. I don't give a rat's ass about your common law jurisdiction saying age of majority is 18 or age of majority is 21. That's their decision. When I feel I have educated my child, or excuse me, my legacy, in a qualified capacity that he can now exit my temple, our temple, here in earth, in a fashion that he can go build his own temple and have a good, wise foundation on which to build his new foundation for himself, I do that. And again, if I determine it be at a sum of years of 16 and so many days, months, as opposed to 27 years and some days, then so be it. If somebody else not determined that for some of 26 years and some odd days, then that be their choice, that be their yay, that be their nay. They have that right, just as I do. See, I did a video a couple years back about quit whining about your rights. You don't have rights. You have a responsibility first and foremost. As soon as you're born, you already have an inherent responsibility. And just because your mom and dad coddled to you until a certain number of years, there's going to come a time in your life where you have to come to a cognizant realization of your own authority and the great responsibility that comes with it. We all hear about that Spider-Man thing where Peter's explained to him that with great powers comes great responsibility. When you're born, you already have a great power in you. And as a mom and dad, that greatest power is supposed to be the prosperity and abundance of exerting your own power in the right fashion, so that those that you're exerting that power over, those that you're taking responsibility of and teaching how to use that power, can grow up and learn how to use that power even greater than yourself. And by subjecting yourself to signing your documentations and letting everybody else take that responsibility, you not only diminish your own abilities, character, but you are literally destroying your own legacy. I urge you people, if you really want to fight for your children, and you really want to profess how much you have this responsibility, quit crying and whining about your rights and comprehend how important the rights of those little ones are and how to project that as your message. See, all these people coming in and doing these statistics and creating these documents saying you have to sign this for the Census Bureau. I don't give a shit about your numbers. I don't give a shit about your names. I don't give a shit about your doctrines. I don't give a shit about any of it. Like I said before, your children are my children. My children are your children. When it comes to the case of a barren mom who can't have children for some reason, is she supposed to go around hating children? Is she supposed to go around ignoring children? When she's in the presence of children, is she not also supposed to treat them as if though they were her own? This is the foundation of their separation. This is the foundation of their separation, whether it be a financial class, an educational class, a color class, a locality class. I don't care what kind of statistics they're running. It's the number of the beast, and you're allowing them to do it by sending your own children off to a grading system that says, okay, once they pass this grade, they can go from 1 to 2. See, in that school, they're still calling them by a number. They're not calling them by a name. You go to prison, guys. I've been to prison. I've done my stint. 18 years old, 3.5 years for a dumb mistake that should have been a 5th degree theft, but the system railroaded me. I got a 2nd degree robbery. I got to live with it. I got to deal with it. It's my own damn fault. But one of the lessons I learned is I don't want to be called a number. I don't want to be called a name either. I want to be called your brother. Doesn't that make sense? Anyway, like I said, I posted those yesterday. You go down on my page and you'll see got several links telling you to pay attention. It's got all the material there. You can read the same links I just read to you. It's going to have all the same material, and I urge you guys to look up those cases, review them, look at the wording, educate yourself, and realize you need to quit arguing and complaining about your own rights and get down to the deep issue. Go down that rabbit hole. How many of you are willing to give up thinking about your own rights and supersede it with the rights of somebody else? How many of you are willing to give up your rights and make them supersedent the rights of others? You can't uphold your own rights unless you do it. That's your fallacy. That's the fatality to your case. I don't care what case it is. So in the meantime, I'm done for today. I get done here. I'm going to post my the links to my other forums, like I said. That will include my PayPal link, and I would really appreciate you guys helping me. Send me some love through that PayPal link. I'm not going to quit doing this, but I need your help too. So if you want to help me that way. I would really appreciate it. In the meantime, remember, if it wasn't for you guys, I wouldn't be doing this. If I was looking out for just me, why would I be doing this? My children are up and gone. And this isn't the first day I've been doing it. So think about it. If it weren't for you guys, I wouldn't be doing this. God bless. Love you. Have a good day.